Well, good morning and welcome. My name is Malcolm Neekirk, and this is, I think, our sixth coffee break briefing of this year. This morning's topic is on the general theme of members' voluntary liquidations, and within that I'll be looking at the specific issue of indemnities to shareholders. This is a somewhat technical issue, I know, but I've seen that practitioners generally have been doing a large number of MVLs lately, so I think it's probably quite a common issue to be dealing with. In terms of what we're speaking about today, I don't think I've got any other particular messages to say to you. So if you're ready, I will get started on the presentation itself. So the themes I'm going to be talking about this morning, I'm going to be starting by looking at why we use indemnities in voluntary liquidations. I'll be moving on from that to look at the formal statutory procedure for distributions that voluntary liquidators are supposed to follow, but usually don't. I'll be looking at the normal shortcut, which is the reason why the indemnity is usually necessary. And I'll be looking at what the situation might be if there were an MVL without an indemnity. I'll probably skip over the slides where I'll be looking in detail at the shareholder's point of view and the liquidator's point of view, simply because I want to keep this down to the usual 30 minutes, and I think otherwise I'd be at risk of going somewhat over that. I'll then be moving on to look at different forms of indemnity. I've got two there listed, the short and simple, and the long and complicated, but there is a third that I have unfortunately sometimes seen, which is the muddled and overcomplicated, which of course is not an advisable version. And I will also be looking at some practical points as well, and when indemnities may get complicated and when you may need to call on additional assistance in dealing with those cases. So let's start by looking at why we use indemnities, and the commercial justification for this. The commercial reason really is that it allows you as the liquidator to make an early distribution, and that way the shareholders get most of the money that is due to them from the MVL very soon after appointment. If it were not for the indemnity, then the liquidator would be likely to follow the statutory procedure, which would mean advertising for claims for creditors, waiting for those claims to come in, followed by further time to process them and pay them before the shareholders could get their money. Now, of course, even when there is an indemnity and you're making an early immediate distribution, you would normally want to hold on to enough money to pay those creditors' claims that you know you're going to have to pay from the liquidation, to cover your own fees and expenses, and in many cases also as a contingency. So let's start by looking at the formal statutory procedure for distributions. Now, one of the things I do like about the 2016 insolvency rules is that for the first time, they recognise that members' voluntary liquidations are a distinct procedure. Although it's called a liquidation, in actual fact, the three different types of liquidation are, in my view, all sufficiently different that they should each be regarded as their own standalone procedure. And part 5 of the insolvency rules is the bit that contains the rules that are specific to MVLs only. MVLs are, of course, an insolvency procedure, even though the company is not insolvent. The liquidator has to be an insolvency practitioner, and the procedures that have to be followed are those set out in the Insolvency Act and the insolvency rules, and those include Part 14 of the insolvency rules, which contains the general rules applicable to all insolvency procedures for creditors to prove their claims and for the office holder to distribute payments to creditors. In the case of an MVL, doing it by the book before paying either a final distribution to creditors or a one and only distribution, then you should be gazetting a notice to creditors, which will give them at least 21 days to prove their claim. And the notice should also set a distribution date, which shouldn't be more than 2 months after the date that you are giving them for proving their debts. The note should tell them that you won't be paying them if they fail to prove in time. And you should also send a similar notice to all creditors you know about who have not proven their claims. And you've got a discretion to advertise generally if you think that that would be worth doing. Once the date for creditors to deliver their proofs to you has passed, you then have 14 days to make your decision on any claims that you have received. And in that time, you have to decide whether you're going to accept them or reject them in whole or in part. And you've got a third option as well, which is that if it's complicated and difficult, you've got the option of making provision for them, setting aside enough funds to pay later if the claim turns out to be good, whilst meanwhile getting on with the distribution to other creditors and asking for more information, more advice, so that you can make your final decision on the difficult and complicated proofs that you've had. Suppose a creditor delivers their claim after the closing date. That doesn't mean that the claim will automatically be rejected. You've got a discretion to accept them, but you don't have to accept them. And I'll be saying a little bit more about that in a few minutes. So essentially what this means is if you're doing an MVL by the book, and there are relatively few MVLs where they are done this way, you will be advertising for claims, waiting for 21 days, and you will then be paying within 2 months, within which time you have to, or it's sensible to wait for the 21-day appeal period to pass. And you do have the option of providing for difficult claims or even postponing the distribution in general. And the important thing is that once you have done that, you have complied with your duty as liquidator. And if a late claim does come in, it is still going to be a claim against the company. The company is not released from its obligation to pay the creditor. It's not released from the contract or whatever basis the creditor has got from making the claim. And the creditor could, if they were minded to do so, they could present a winding up petition against the company to put it into compulsory liquidation. However, although the company is at risk if a claim comes in late, you as liquidator are not at risk. You will have performed your duty. So it's a decision really for the company as what to do with late claims. This slide shows really the process for doing claims by the book. So following appointment, you will gazette the intention to make a distribution, and then at least 21 days later will be the last date for proving. Once claims have come in, you have to wait at least 2 months. Sorry, you should wait not more than 2 months before distributing to members, but within that time, you need to allow enough time for your own 14-day decision period, because you will have to make a decision on proofs within 14 days. And after you've made a decision about a particular proof, the creditor has got 21 days to appeal against it if dissatisfied. Once you've done all of that, you can then make the distribution to members, and that is likely to be the conclusion of the MVL for most practical purposes, and you can move on to release and then dissolution of the company. Let's look now at the normal shortcut, which is the procedure that's followed by most MVL liquidators. And here you are likely to appoint as soon as the declaration of solvency is ready to be sworn, as soon as it is sworn. And you're likely to add a deed of indemnity to the bundle of documents that you'll be asking the directors and shareholders to sign. You will normally ask them to send the company's funds into your client account, although they may themselves distribute most of the money by way of loans, which would then leave you with a distribution in specie to deal with as liquidator. And you will hold back, you'll keep in your client account enough to pay the liquidation expenses, enough to pay any creditors that you know about, and you may hold back a sensible contingency as well, and then pay the rest to the shareholders. If you're doing this prudently, you will, whilst doing all of this, you will also gazette for creditors, so that you've got the statutory protection that is granted to you by doing that, and then you will close the liquidation as soon as you can. So that's the normal shortcut. Now let's look at what the situation would be if there were no indemnity here. Now, in a case where you're doing it by the book, the chances are that you may not have an indemnity, because in many of these cases, it's considered unnecessary to have an indemnity. So what happens if an unexpected claim comes in before the last date for proving in a case like that? In that case, you don't have a discretion. You have to admit the claim, as long as it is a valid one, and you have to pay it if the company has enough funds. If the company doesn't have enough funds, if it's an unexpected large claim, then you'd have a discussion with the directors and shareholders about whether they would wish to make funds available to pay it, on the basis that otherwise the MVL will have to be converted into a CVL. Now, suppose the claim comes in after the last date for proving. Now, in that case, you have a discretion to accept it, where it's come in after the last date for proving, and here we'll assume that it's come in while you've still got funds, because you've not yet paid the distribution to members. So you've got the option of admitting it, but if you don't admit it, then the company will still owe the debt. The creditor may present a winding up petition, and they may apply for a freezing order. If they've got grounds immediately to present a winding up petition, then of course the winding up petition itself would prevent you from distributing the funds to the shareholders. So the chances are that if a claim comes in late, but before you've distributed to members, chances are that you are going to be likely to accept that claim if it's a legitimate one. Let's look at the situation here where there is a very late claim and it's come in after the last date for proving, and indeed even after you have distributed funds to the shareholders. Again, same situation here. The company does still owe the debt. Creditor may present a winding up petition, but there are no funds available to freeze either by a freezing order or by a winding up petition. And if they do appoint a compulsory liquidator, then the compulsory liquidator is likely to be investigating the distribution as some form of antecedent transaction. Doesn't necessarily mean that they will have any grounds for setting it aside, but they're likely to want to be looking at it to see whether there are grounds for doing so. However, in a case like that, where you have followed the statutory timetable, you've gazetted for a distribution, there is going to be no claim against you for misfeasance. You as liquidator will have done your duty, so you are going to be protected. Now, in cases where it's being done quickly, not necessarily by the book, and without an indemnity, in this particular case, I'm imagining that the liquidator has been prudent, and although they've made an early distribution to members soon after their appointment, they have also gazetted that distribution. They've not followed the timetable, but they've set a last date for proving, and here the claim has come in after that last date for proving. In a case like that, I don't think it would be a misfeasance, because essentially the voluntary liquidator will have done their duty, and the claim will be outside the last date for proving. But as before, the creditor would be able to bring legal action against the company for non-payment, would be able to put it into compulsory liquidation quite probably. I'm going to skip over the next slides dealing with these in more detail from the shareholder's point of view and the liquidator's point of view. If you would like a copy of these slides afterwards, then please drop me an email and I'll be happy to send them on to you. But I don't think I've got a great deal of time this morning to go through them in any great detail. So I'm going to skip on now to look at the different forms of indemnity that are available. And as I say, there's the official ones which are short and simple and long and complicated, and then there's the unofficial ones which are muddled and overcomplicated. And broadly speaking, this is a sort of massive generalization about all types of legal risks. The more that is at stake, the more difficult, complicated and expensive it will be to sort out disputes over the amount at risk. So at the bottom end of the scale, if it's a relatively modest amount that you are looking to claim back to pay a creditor in an MVL, it may take no more than a phone call or perhaps an email to set out your reasons, possibly getting a lawyer to draft a letter to do it. At the other end of the scale, you may find that you actually need to issue proceedings. It could be turned into a contested case, and worst of all worlds would be very senior barristers on both sides. In terms of preparation for this, I would say that for most claims that you may be likely to need to make under an indemnity, you can probably cover it with a simple indemnity, and my definition of a simple indemnity is a one-page document, properly drafted of course, but I think you can get most of what you need from an indemnity onto a single page. Where you draw the line is of course a decision for you and your own attitude to risk, and for more sophisticated cases, I would say most cases which you can cover with a standard indemnity that doesn't actually need specific negotiation with lawyers on both sides, I would say that you can get pretty well all that you need in an indemnity into a standard document that is 4 pages long. And that's what I mean by a comprehensive and long indemnity is really just 4 pages. A couple of checklists here for you. For the indemnities that you use, it's terribly easy because so many indemnities are drafted on the Blue Peter principle. You pull out the last one that you did on the last MVL you dealt with, and you change the company name and number and the names of the shareholders, and you get them to sign that. Only so often the company name and number may not be changed, and I have seen this with indemnities where the company has been the wrong company or the shareholders have been the wrong company. So it's worth having a second person just check that on the indemnities that you use to make sure that they are correct for the particular case. The modern tendency with indemnities that I see increasingly now is for the indemnity to be addressed to the company as well as to the liquidators, and there seem to be some good reasons for doing that. And the other thing that I think you need to make sure is right in a basic indemnity is to make sure that the shareholders are jointly and severally liable for any claims that are being made. The longer 4-page indemnity that I've talked about will have these additional points covered in it. There will be a provision in there to cover any future block transfers that may change the liquidator to make sure the new liquidator is also covered. The indemnity should be extended to protect your practice and the other people who work in it, as well as just the liquidators. You'd need to make sure that there's a good and effective description of the sorts of claims for which you can make an indemnity call on the shareholders. I would suggest a standard indemnity should exclude in careful terms the negligence of the liquidator, because that's often a controversial matter in drafting these things. So I'd suggest you might as well offer it as your standard anyway. I've seen some good modern indemnities that ask for warranties from the shareholders, and that's good practice because you're going to be relying on information from the shareholders in terms of making sure that your appointment is valid and that you are distributing the right amounts to the right people. So to have a warranty back from the shareholders that they have provided accurate information to you is very, very useful. There's usually some careful wording about how long the indemnity will last for, and the 4-page indemnity will contain contractual boilerplates. These are the sorts of dull, boring clauses at the back that nobody but the lawyers ever read, but which can sometimes make the lawyer's job rather easier than they would otherwise be. And also, they would be set up so that, as standard, they would be executed as a deed. Again, there are technical reasons for that. So those are the different sorts of indemnity. I'm now going to move on to look at some practical points to cover situations when indemnity arrangements can get complicated. And I will look at each of these in turn. But the first of them that I'll be looking at is where there's an overseas element, particularly overseas shareholders. Second one I'll be looking at is non-aligned shareholder groups. And I suppose what I mean here is that an awful lot of the MVLs that I see are basically single member consultancy companies. They may have husband and wife as members, but they're basically got very, very few shareholders to them. And what I mean by non-aligned shareholder groups is where you've actually got perhaps different business partners have come together in the company, and they don't have exactly the same interests as each other in the way that a husband and wife as shareholders of a company would have. Can be complicated as well where you've got shareholders who are not beneficial owners of the shares and who are holding the shares on some sort of formal trust. And it can be difficult if you've got corporate shareholders as well, where you would need to be particularly careful to assess the value of the covenant that they can give. Distributions in specie can be problematical as well for indemnities. And I've mentioned a couple of times that many modern indemnities do say that you're not expecting the shareholders to indemnify you against your own negligence. I'll say a bit more about that in a minute. And you sometimes will have an MVL with dozens, possibly scores or hundreds of shareholders, and indemnity may not be appropriate. There was a recent case I was involved with where we actually dealt with that with a loan arrangement instead. So looking at each of those in turn, there are broadly 3 problems that can arise from foreign shareholders. First one is foreign law, the second one is foreign courts, and the third one is assets in foreign places. And looking at foreign law first, just as one example, in France, personal guarantees are time limited, and if they're not regularly refreshed, they will expire. I don't know whether the same would apply to an indemnity. I don't want to find out. And normally the indemnity will say that English law will apply to the indemnity. That will take you so far, but if you've got overseas shareholders, you may find yourself having to convince a foreign court that that English law still applies. And again, the indemnities that we use, the 4-page ones, would normally say that the courts of England and Wales will have jurisdiction in any claim arising under the indemnity. But of course, if you've got an overseas shareholder, you may have to serve the court papers on them overseas, which could be complicated, difficult, and expensive. And even if you can get a judgment in the courts in this country, you would then need to register that judgment in the court overseas to enforce it. And again, depending upon the jurisdiction, that may well be complicated, difficult, and expensive. And if you've got a judgment and you're trying to enforce it, if the shareholder does not voluntarily repay the money that's due to you, you may find that it's actually very, very difficult to enforce a judgment against them. overseas. For example, many states in the United States have homestead protections for debtors that effectively exclude the family home, which can have a tremendously broad definition, from any sort of bankruptcy or enforcement proceedings. And there can be practical problems of whether you can even find the shareholder in a foreign country, whether you can find the assets there. And there can be language difficulties, which means that dealing with overseas advisors means that very often there's a lot of scope for misunderstanding and miscommunication as to what is in mind. I mean, even the word liquidation will not translate into an exact equivalent procedure in a foreign country necessarily. Second one to talk about is non-aligned shareholder groups. And I say you would normally have your basic indemnity would say that all of the shareholders are jointly and severally liable for any calls that are being made. And that will work if it's a family company with a relatively small number of shareholders. But if the shareholders are unrelated, then you may find that they're not willing to be jointly and severally liable, in which case you may have to have some sort of fairly complex liability sharing arrangements attached to the indemnity, with provisions in there for picking up any shortfall if the individual shareholders don't promptly pay what you are asking them to pay. If you have shareholders who are trustees, they will not be beneficial owners of the shares, and they are likely to want to limit their personal liability, which is quite reasonable. They don't actually own the assets personally, so they wouldn't want to take personal risk for doing that. And you'd need to look quite carefully at the extent to which they want to limit their liability, what they are offering you instead, and whether it's going to be acceptable. In a case like that, you may decide that actually you are not going to take an indemnity after all, which you may decide with a foreign shareholder as well. Similarly, if the shareholders are other companies, you would have to have a look at the value of the covenant that each of them is giving, because it may be that if they're merely an intermediate holding company, they themselves will be wound up fairly swiftly after the distribution has been made, in which case their covenant may be worth very little. With a distribution in specie, you need to be sure how you're going to be valuing the asset, and how the shareholder's liability is going to be capped, because normally you would limit the liability of shareholders so that they are not duty bound to return more to you than the value that they have received from the liquidation. And it may be worth looking at what the shareholders' plans for the asset is going to be. Could be problematical again if the asset is a company in an overseas jurisdiction, particularly if the shareholders are planning to move there. Many indemnities do say that you will not be able to make a claim for a liability that has arisen if you are negligent. Many indemnities also ask for an indemnity against claims that arise because the appointment is defective. And there is an argument to say that if the appointment is defective, well, all of the papers will have been prepared by you. That therefore suggests that if there's something wrong with the appointment, you may have been careless yourself in preparing them. So that can be difficult to negotiate. And as I say, many modern indemnities do include a warranty from the shareholders on the accuracy of the information that they have provided to you and on the validity of the resolutions that they have claimed to pass. And I mentioned a case that we've been involved in recently where we had a very large number of shareholders, and what we did there is we actually made a pre-liquidation loan to the shareholders who wanted it, so that they got the money immediately. The liquidation was likely to take some time to conclude. We knew that was going to be the case. And then having distributed most of the money in the company to most of the shareholders by way of a loan, then when it came to making the final distribution, we were going to be making a distribution in specie of the loans back to the shareholders who had received them. And in difficult cases, this may be a good alternative to an indemnity, where the loan is made on terms that if you need the money back for the purposes of the liquidation, you can call upon the shareholders who have borrowed money from the company to repay their loans. Let's finish by looking at some practical, some summary points of points that I've covered. So I'll just dash through those fairly quickly. First one is the modern tendency is for indemnities to be addressed to the company as well as to the liquidators, and you might want to just have a quick look at your standard indemnity to see whether they are in conformance with that modern practice. I know that there are many liquidators who do like to use short, simple indemnities, no more than 1 page long and in plain English for the smaller MVLs that they deal with. It becomes so much easier asking for an indemnity from shareholders, particularly if it's a single member company, if it is just a 1-page document and it's pretty clear on the face of it what it is there for. And if the value is not so significant, then there's not much risk that's being taken by using a short form of indemnity like that. And if you do use short, simple 1-page indemnities for the smaller MVLs, I'd suggest you probably do need a more detailed indemnity, by which I mean one that's 4 pages long, for mid-tier MVLs. And I think you would have to decide where you draw the line between the small MVLs and the mid-tier ones. For the very largest and most complex cases, you may need to get a lawyer involved to review the indemnity, perhaps to fine-tune it for the specifics of the case that you need. And if you are unlucky, you may need them to negotiate it with the other side on the most complex cases. Unfortunately, it's likely to be your clients who will decide which cases those are going to be when you get a letter back from their lawyer approving the draft indemnity subject to the amendments in red. And I think the point there is to make sure that your standard engagement letter for MVLs does expressly allow you to charge for legal advice that you have to take if it is a large and complex case where you need a lawyer to draft the MVL, or if you are involved in negotiating the indemnity with the lawyer acting for the shareholders. In some cases, it is going to be very difficult to take an indemnity, or at least to take an indemnity that has any real commercial value to you. And those are cases where you probably should be distributing by the book rather than by the summary procedure. And in some cases, perhaps where there are many shareholders, you could make a loan, or the company could pre-appointment make a loan to those shareholders pending the final distribution. You would want to be involved in that so that you can make sure that the loan document works to allow you to call back money as you would with an indemnity. Good practical point here is use well-designed forms. I've seen some where you have to type the company's name into the document several times. I have seen some where you have to make deletions, alterations, or insertions into the body of the indemnity. There is no need to be drafted that way. They should be put together in a way that you just have to put information onto the front and the back sheet only, and the body of them does not change. The more you have to change an indemnity before you send it out, the more the chances of mistakes. And do make sure that you have a master blank template somewhere in a safe place where everybody who needs to prepare indemnities knows where it is and knows that that's the one that they should go to and use when they prepare an indemnity, rather than taking the path of least resistance and just picking up one from the last file that they used. So there we go. If anybody has any questions, then I'll be very, very happy to deal with them now. Let's just get back onto the slide again. There's just a few dates for your diary I'd like to mention now. First one, haven't yet got the date for it, but we will be running our second annual insolvency conference probably in June next year. I will be speaking at the SESCA conference at Reading University on the 8th and the 9th of September, and also at the SESCA Insolvency Seminar in Tempest Wine Estate on the 6th of October. So I hope to see many of you at those. Details are on the SESCA website. And I am also recording an online presentation later this month for Neil Taylor for the NTI TAP app that he uses to provide updates and training on insolvency matters. And I've not been invited to speak at the last two on the list, but I will be attending them. There's the R3 SPG forum. I think it's actually Sutton Coldfield rather than Birmingham on the 3rd and 4th of November this year. And the local region of R3, Southern and Thames Valley, will be having a forum in Reading in late March next year is the likely date for it, which I will also be attending. So I hope to see many of you at least one of those, if not all of them. And with that, let me just see if I've got any questions in from anybody. No, I don't. So with that, I will say thank you all very much, and I hope to see you again next month when the presentation I'm likely to be delivering is a refresher on GDPR. And that is, just look at my diary, that's in September. The date for that is the 12th of September. So that will be a refresher and general update on GDPR for you. Look forward to seeing you then. Thank you all very much.